So, when you think of the crime of arson, what comes to mind? Probably a huge fire, right? A building engulfed in flames. But in the eyes of the law, it's actually way more specific than that. It's not just about the size of the fire, but what was going on in the mind of the person involved. It's a fascinating legal puzzle. Okay, let's dive in.
But first, you know the drill. We've got to put this out there. This explainer is for educational purposes only. It is absolutely not a substitute for professional legal advice. We're just exploring the concepts here.
So here's how we're going to break it all down today. We're going to look at the building blocks of an arson case. First, the act itself. What does burning actually mean legally? Then we'll get into the intent, the mental state. After that, we'll look at how in the world do you prove a case when the evidence has literally gone up in smoke? And finally, we'll wrap it all up.
All right, let's start with that first piece of the puzzle, the physical act. This seems like it should be pretty simple, right? But the legal definition might just surprise you.
So if you look at the actual law, in this case, California's Penal Code, it says arson is setting fire to, burning, or, and this is key, causing to be burned any kind of property. That language is written to be super broad on purpose. It means you don't even have to be the one who lit the match, just the one who caused it to happen.
Now, this is where it gets really interesting. Just how much damage do you need? Well, not much at all. This quote from a landmark case, People v. Ashby, says it all. The burning of any part, however small, completes the offense. Let that sink in. You don't need a whole building to be destroyed. Not even close.
And to prove that point, look at these examples from actual cases. We are talking about the slightest evidence of a fire. Just some charring on a wooden cabinet? Yep, that counts as burning. Some melted plastic light fixtures? That's burning too. Even damage to wall-to-wall carpet is enough, because it's considered part of the structure. It's pretty wild.
Okay, so a tiny scorch mark can be the act. But that's only half the story, right? Just because something is burnt doesn't automatically mean a crime was committed. So let's move on to the second and equally crucial pillar of an arson case, the defendant's state of mind, their intent.
For any act of burning to legally be considered arson, prosecutors have to prove that the person acted willfully and maliciously. Now, these aren't just dramatic, made-for-TV words. They have very specific legal meanings that are absolutely essential to making a case.
So let's break down maliciously. You might think it means having some deep-seated personal hatred for someone, but legally, nah. It just means you intended to do something wrong. The definition is right there, a wish to vex, annoy, or injure, or simply the intent to do a wrongful act. It's a much lower bar than you might think.
And this leads us to a really important legal distinction. Arson is what's called a general intent crime. What that means is the prosecution doesn't have to prove that you intended the final result, like, I'm going to burn this entire building to the ground. All they have to prove is that you intended the act that started the fire.
This quote from the case, People v. Atkins, just nails it. The focus is on the general intent to willfully commit the act of setting on fire. So, if you intentionally light a firework in a field of dry grass, you intended the act of lighting the firework. The field catching fire is the natural and probable consequence. That's general intent. See the difference?
Okay, so we've got the act, which can be a tiny burn mark, and the intent, which is a general intent to do wrong. But think about this for a second. How on earth do you prove any of this? The crime of arson literally destroys its own evidence, and, people tend to run away from fire, so there are rarely any eyewitnesses.
Well, the answer lies in circumstantial evidence. The courts have known this for a long time. This key ruling from People v. Beagle basically says, look, we get it. Direct proof is going to be rare in these cases. So instead, the prosecution has to build its case from all the little pieces of evidence surrounding the event, like putting together a giant puzzle.
So how does that puzzle get put together? The case of People v. Belton kind of gives us the playbook. Prosecutors will try to weave together a story using these points. First, show the defendant was there right before the fire. Second, have investigators testify that they ruled out all accidental causes, like bad wiring. Third, present evidence that it was intentionally set, like finding an accelerant. And fourth, this is a big one, showing that the fire started in more than one place at the same time. None of these things alone are a smoking gun, but together, they start to paint a very clear picture.
All right, let's bring all this home and recap the two absolute pillars that have to be there for an arson conviction to stick.
It really does boil down to these two things. On one side, you have the act, any physical evidence of burning, no matter how tiny. And on the other side, you have the intent, proving the person acted willfully and maliciously.
which remember can be inferred just from their conduct.
And here is the absolute bottom line. You cannot have a conviction for arson without both of these pieces. A prosecutor has to prove both the physical act and the wrongful intent beyond a reasonable doubt. And almost always, it's that carefully constructed puzzle of circumstantial evidence that acts as the glue, holding the whole case together.
And that really leaves us with a pretty fascinating question to think about, doesn't it? In a crime that so often erases its own tracks, we have to rely on inference and circumstance. It makes you consider how our legal system works to find the truth, balancing this compelling story built from puzzle pieces against one of our most fundamental principles, proof beyond a reasonable doubt.